See if you have a question.
Okay. Yeah, attendees are coming in. This is the Zoom for the meeting of the Committee on Revision of the Penal Code. We are doing a little bit of testing just to make sure that everything's working as expected. And the chair, Michael Romano, will start the meeting momentarily. So welcome, and if you could just hold briefly, we'll be going soon.
I'll ask a question.
Just talk for him. You're on off mute.
Can I ask a question?
Yes.
When we're going to send stuff over to the staff to do what? If we got recommendations, we're going to send it to staff to make sure it's the right code section or what?
Yes, I don't even think we'll get that specific to the code section tomorrow, but yes, we will tomorrow's part of the meeting, we will set priorities for the staff to then research, and then they will come back to us at the next meeting to report back on, and at that point we'll be more into what specific code section and language.
I mean, I don't understand. We have recommendations and they go to the staff to do what?
To distill them down and to actually write the draft language, which we will then discuss before.
Got it. Thanks.
Okay, Mike, I think you're good to start. I will, I'm going to take myself off video and I will track down Senator Skinner and see if she needs help connecting.
All right. Hi, everyone. Good afternoon and welcome to this online special meeting of the Committee of the Revision of the Penal Code, which is now in session. I'm Mike Romano, chair of the committee. I appreciate everyone joining the committee today in these current circumstances and in this unique format. Before we get to the substance of our work today, I'd like to cover some technology, procedure, and ground rules. First, we'll soon hear from 3 panels of witnesses. Each panel will take about an hour. Panelists, please be advised that we have read your written submissions, which are now public, so there's no need to repeat yourselves by reading from those documents during your testimony. Members of the public will have a chance to comment at the conclusion of the 3rd panel, which should be around 4 o'clock. If you have a comment, please click the raise your hand function on your Zoom account, or if you're calling in, please hit *9. Do not do this now. Please only raise your hand once I announce the beginning of the public comment period. Okay, with that said, I'd like to begin a roll call of committee members. I will call your name in alphabetical order. Please say here. Senator Burton?
Here.
Judge Espinoza?
Present.
Assemblymember Kamlager?
Here.
Justice Moreno?
Present.
Dean Richardson?
Here.
And we're still waiting for Senator Skinner, but we have a quorum, so we're going to proceed. So to the substance of today's hearing, our topic today is alternatives to incarceration. The legislature has specifically directed us to study this issue, but I also suspect that we'll hear from panelists today that there's thirst in California for expanding and improving alternatives to incarceration that help people stay out of jail and prison in the first places, and in appropriate cases, avoid prosecution altogether. I really have to stress that the scope here is large. According to the best and latest available state data, over 1 million people are incarcerated in California jails and prisons every year. The vast majority of this group, up to 90% or 900,000 people, were arrested for misdemeanors or nonviolent felonies, according to the most recent data from the California Department of Justice. Many of these people are likely to be the exact population who would benefit from the programs we will discuss today. Support for alternatives to incarceration cuts across politics and ideology. In 2017, President Trump's Commission on Combating Drug Addiction and the Opioid Crisis, quote, urged states to establish drug courts in every county. And the most recent diversion program in the Penal Code, targeted at primary caregivers, was authored by our own Senator Skinner. Most recently, the Alternatives to Incarceration Working Group in Los Angeles County, which includes Judge Espinoza, issued a landmark report containing over 100 recommendations to begin addressing these issues in the jurisdiction of the country's largest jail. As the chair of the working group put it, our jails are filled with people struggling with homelessness, poverty, mental illness, and addiction. The justice system is ill-equipped to respond to these human conditions, resulting in far too many people cycling in and out of jail instead of getting the support they need to lead healthy and productive lives. So the need on these issues, even before the public health issues presented by the spread of COVID-19, is pressing. But I expect that we'll hear from our panels today, many of the diversion programs, collaborative courts, and restorative justice conferences in California operate in the shadow of the penal code. They have no clear authorization from our state laws, and that gives me pause. At the same time, the committee should not recommend an intervention that is unnecessary or harmful because it may freeze these programs in time and prevent further progress. The question of what role the penal code should play here will be at the front of my mind as we hear from today's panelists. As we hear from the panelists, I'll also be thinking about how alternatives to incarceration can promote public safety, ensure justice, reduce recidivism, and grow healthy communities. We are also particularly interested in data that shows how alternative programs can reach these goals. Our panelists today are extraordinary. I will introduce them individually, but I want to thank them all now for giving the committee so much of their time and sharing their experience. Our work would be much poorer and really impossible without your insights. Hi, Senator Skinner.
Okay.
Hi. So with that said, I'm going to turn to the panelists. Tom, will you please turn on the panelists?
They're on. They're good to go.
Great. So with that, I would like to turn to our first panel, which is on collaborative courts, which are generally spaces in the criminal system where the typical adversarial roles are put aside and all parties work together to address the root causes, such as mental health or substance use issues that led to being involved in the system in the first place. Panelists, as I mentioned, we have read your written submission. The best use of your time is to make recommendations to us on how to address California's penal code. And please be as specific and concrete as possible. You'll each have 5 minutes for an opening statement, and then we'll go to Q&A from committee members. Please note that I will be enforcing this time limit as vigorously as possible. So with that said, we're happy to be joined by Judge Richard Vlavianos, apologies for pronunciation, from San Joaquin County Superior Court and Chair of Judicial Council's Collaborative Courts Committee, Judge Lawrence Brown from Sacramento Superior Court and Vice Chair of the Judicial Council's Collaborative Courts Committee, and Judge Stephen Manley from Santa Clara County Superior Court, who's also on Judicial Council Collaborative Courts Committee. Thank you, judges, for being here. Judge Vlavianos, can you kick us off?
Okay, thank you.
Thank
I
you.
want to thank the chair and the committee for letting us be here in front of you today. All of us are always happy to share about our collaborative courts. The comments of myself and my colleagues are limited because we don't speak on behalf in this proceeding of the Judicial Council or any form of that. We're here as individuals. Would love to get specific for you, but individually there are some prohibitions we have about taking positions on legislation and pending legislation, but we are more than happy to give you all the information that you need and answer any questions that you have as it relates to collaborative courts. As in the written comments, we are quite extensive in the state of California, over 400 collaborative courts statewide, in every county except 2 of the smallest counties in the northern part of the state have at least one collaborative court up and running. So we are using them relatively extensively. The key for what we do in collaborative courts is there's a change of focus on reintegration of an individual into society. So instead of a focus primarily on punishment and punishment as a method of changing behavior, the switch is to go to looking at supervision and effective supervision as the way of changing behavior and the evidence-based tools that come along with it. So instead of looking at like a lot of jail, and then not paying a whole lot of attention to what happens after the jail. The concept is to spend less of a focus on the jail part, which will come along with the criminal offense, and more focus on the supervision part. And it allows us to use evidence-based principles that are out there, because there are a lot of really great evidence-based principles out there on behavior change that collaborative courts are applying that allow us to get some very, very good results. They've been proven to reduce recidivism. A couple of examples from our county and our DUI court: the recidivism rate went down 32%, collisions went down 50%, and our filings went down almost 70% when we applied a really global approach to that. Most notably for me, when Realignment came down, our community corrections partnership, the executive board, actually decided to invest in some courts to deal with the AB 109 population that was modeled after what we were doing with parole in our parolees and our parole reentry court. So we put in 2 courts designed to meet the needs of the AB 109 population. And since Realignment, we went from a county, I'm the backup cap judge or consent decree judge, and we went from a jail that was overcrowded and releasing to a jail that was under capacity even before the COVID-19 days. So we were able to use strategies to effectively deal with people in the communication and the community. And that really does help. There's ways to do it, and there's ways to do it effectively. The nice part is there's a lot of science as long as we study what's happened in the past, use evidence-based principles, and then analyze ourselves to make sure that what we're doing is working. We can get great results. We've actually integrated our collaborative courts into our diversions, all of the diversions. We've integrated them into the traditional probation setting, where a lot of done. And we've also entered in community supervision, which is through probation, and parole. So we've integrated them into all of ours. The theory that I've developed kind of doing this over time is the courtroom as ER triage. When you get somebody, especially somebody who's been in front of you multiple times, that you've seen them before, it's really analogous to an emergency room. You have that person's in front of you. There are injuries out there. There's stuff out there that needs to be dealt with that just the use of jail hadn't been dealt with. So when you look at that person, if you have the ability to screen them, to find out what's going on, assess them to go deeper into the areas that need to go deeper, and then refer them to programming based on a validated screening and assessment, you can be very, very effective. The nice part about the world we're living in, we have some really good validated tools that will allow us to make those kind of assessments and then do that, and then bring them back and use the accountability to the court. The real key is accountability. When individuals are accountable for their behavior and then they're treated in a way that makes it, people think they're being treated fairly, they really do respond so much better than before with the reduction. So we just organized a delivery system all the way on the supervision side, where people who weren't responding to probation or parole get funneled into the courts. We have a court designed to meet each of their needs, and then the court uses the court to help get the response. And our chief of police have been kind enough to give us 2 officers to work with us who are great motivational interviewing. They work with clients extremely well, and they actually help us contact people in the community and keep them from going back in when they're violated. So they work with them. So we put together a pretty integrated system, and you can do it extremely effectively, and it does really significantly help reduce incarceration. Did I make it?
Yeah. Good job. Thank you very much. I'm going to hold up this little sign when people have 1 minute left. Judge Brown, I think we have you up next.
All right, I'll press my stopwatch. Good afternoon, and thank you for the honor of addressing all of you here today. I've been a judge in Sacramento County for the past decade. I've been in the criminal courts the entire time and have presided over most all of our collaborative justice courts now for a good number of years. I'd like to say hello to Senator Burton. I spent many years testifying in front of the good senator in the Public Safety Committee when I was executive director of the California DA's Association, and much of which I accomplished, your commission's now attempting to undo. I am a big fan of the collaborative courts. My phrase with my district attorney, Senator Burton, and others is that I've drunk the Kool-Aid. These courts really produce incredible results. It's been the most meaningful work I've done in my career. In Sacramento County, just in the last several years, we created our reentry court in 2013. The DUI court was created in 2014. The veteran treatment court, 2015. I created a second mental health court in 2016. We have a reset court for young women engaged in prostitution offenses where they are victims of human trafficking and so on. So we have endeavored to do our very best to try to emulate the good work already being done in places like San Joaquin County and certainly Santa Clara County. When my chief assistant public defender at one point said, "Judge Brown, you're becoming our Judge Manley." And I told that to Judge Manley, and he told me, "It was only a matter of time, Larry, only a matter of time." I am, because of my background, I guess, as a local prosecutor and later as a federal prosecutor, as well as being head of the state DA group, have a bias. And the bias is that I think that it's incumbent to have full participation with your local district attorney. And I'm mindful that in some jurisdictions, that's more difficult than other jurisdictions. But to the extent that we are assuring the community that having people no longer incarcerated, but being out in our community on probation, and that we are endeavoring to turn their lives around to address some of their underlying needs, whether it's mental illness or substance use disorders, lack of employment, stable housing, social circles, whatever it might be, that we have to also ensure and can represent that we are very mindful of the public safety aspect. To do that, I know that I hide behind the district attorney's office. One of my key talking points is to say that my DA agrees to these cases coming into the court. They are not resistant. Our numbers have grown exponentially. I'll just put one example. Our mental health court, we now have 2 courts. We're trying to create a 3rd. We have over 200 people participating in the court now at any given time. That is several fold what it was just 5 years ago. And all those persons come in with everyone agreeing that these are appropriate candidates to be in the mental health treatment court. I also would just note this, certainly mental health diversion has played a dynamic in that. That's because, as we know, with mental health diversion, there's no change of plea, there's no formal probation supervision. So to the district attorney, my mental health treatment courts are pretty good. There's a change of plea, they're on probation. We dismiss the case when they graduate, but at least they have that locked in with active supervision. What's happened is we have scores of people on mental health diversion, but largely for misdemeanors. But my felony numbers in mental health courts are way up because we look darn good, right? And so I do think there is an interplay between diversion and these collaborative courts that continues to need to be looked at in a close and meaningful way. So again, thank you for the opportunity to be here today.
Thank you. Look forward to talking to you further. Judge Manley.
Thank you very much. It's a real privilege to be able to testify before you today. I realize you've read my written comments, so I'm going to focus on some issues that I hope you will look at and consider. Practical things. I've been doing working in treatment courts for 30 years, and I have perhaps the largest mental health treatment court. I supervise and monitor about 1,500 to 2,000 offenders. What I want to talk about are really some specifics. One is, to begin with, I feel very strongly, and I have for years, we had a group, a task force that reported and made recommendations to the Judicial Council regarding changes in the law and practices that we felt were important. And I want to stress one from the outset. I believe that our sheriffs and our counties and our jails should be required to provide discharge planning for mentally ill offenders, for offenders who are medically stressed, very vulnerable, those who are mentally challenged. And I think that that can be done. I know it can be done. And I know the legislature has acted previously in this area with relationship to the homeless who are in hospitals. So if you look at Health and Safety Code Section 1262.5, I would use that as the beginning of a model to have real discharge planning in the jails. I don't care how many collaborative courts you have, how many treatment courts you have, you can't reach all the mentally ill offenders. And my experience over these years is seeing them again and again released at 2 a.m. to the streets, the most dangerous place for them to be. They should be discharge planning from the day they go into the jail, treatment while they're in the jail, and then discharge planning that would include connecting them with treatment when they get out of jail. The second thing I hope you consider is in the area of incompetency to stand trial. I've done this for many years, many years working with these offenders, and I'm doing it right now during the pandemic. And what I found, and with all due respect to my dear colleague, Judge Brown, the diversion program really is effective, and that is for the IST population, the felons. I think where we're going wrong is, and where we have failed, is our classification. We divide them up by misdemeanor and felony. And if you're a misdemeanor, it's all up to the counties. If you're a felon, you go to the state hospital. Now we have diversion and the felons, and you can take the felons and put them in the community. My view is what we need to do is reclassify who goes to the state hospital and who doesn't. It's not a question of the charge, because many felons, many felonies, in my view, are perfectly acceptable to be treated in the community. We ought to take the same approach we did with realignment in that area. I think we should stop sending people to state hospitals where the mental illness has been induced by the use of drugs. If you look at the data that they have, nearly 10% of the people in the state hospital, it's meth-induced or some other inducement by a drug. Now, these offenders, I think you can treat much more effectively at the local level. I also think that we should require the courts to reevaluate individuals who have been in our jail too long, waiting to go to the state hospital, to see if we cannot treat them in the community. I think that can be done. The next one I want, oh my heavens, 1 minute. All right, I'm going to go really fast. I think you should eliminate Penal Code Section 3454, which is flash incarceration of up to 10 days, giving probation officers the opportunity to simply throw someone in jail for 10 days. It's not evidence-based. The next one is I would strongly urge you to re-examine all these program requirements for domestic violence, parenting, driving under the influence. These get in the way of a collaborative court being effective. If judges don't have the discretion to provide another program or another alternative for someone who doesn't even understand what they're talking about in these classes, we get nowhere. We simply have people who end up found in violation of probation by another judge because they haven't completed these programs. I also think you should take a hard look at the issue of bench warrants. What we have tried to do is to stop people from coming back to jail. Mentally ill people forget when they're supposed to be in court. They mess up. We need to have a way to move them into another, triage them outside of the jail, stop them from being booked into jail. That is, and I think we could do that. Thank you.
Thank you very much. Thank you for wrapping it up. All right. I actually think I'm sure that all of you have a lot more to say. And I should have said at the top of all of this is that this is the beginning of a conversation on these issues. Our committee is directed to make recommendations to the legislature and governor in January. So we are not making any decisions or final decisions now. This is just, we want to hear from you. We're starting with collaborative courts because it's sort of at the beginning of the criminal process. So please be aware that you'll have plenty of time, and we will be back in touch with you over the course of the year. So thank you very much for your time. With that said, I'd like to open it up to committee members for questions. Yes, Judge Moreno.
Can you hear me?
Yes.
Okay, I just have two questions to the different panelists. Doesn't matter who answers it. First, I hadn't conceived of DUIs being dealt with in a collaborative court system or method. It seems that that's a highly regulated area of the vehicle code with the DMV involved and CHP and so forth. So what is the experience and what are the services available to work with, for example, recidivist DUI arrests? That's my first question. The second question is, it just seems that the panelists have spoken about collaborative courts, and it seems that these courts anticipate or use a variety of services that it seems to me are highly intensive and probably very expensive. I would assume that in the final analysis, when you see results and so forth, that there's a cost savings. At least that would be, besides helping the individuals. But it seems that since they're so resource intensive, I wonder if the financial resources are there to support those. So those are my two, DUI and the resources to handle these programs.
I can start out on the DUI. We do recidivist repeat offenders. First offenders do not come into our program at all. 80% of them you will never see again. It's only when they come back that they get put into the program. And what we use mostly, for most of them, they actually don't need treatment. Most of them just need monitoring and accountability.
Right.
So we'll use ignition interlock device, we'll use transdermal monitoring, we'll use other technologies. And if they do it right, they only have to see me 3 times over the course of a year, and they're done. All I need to know is that they're not using alcohol. So we do abstinence, and then we just monitor the abstinence, and then we do have a treatment section for those who actually need treatment. So somebody who needs treatment, we have a screening tool that tells us which category they go into. If they need treatment, then it's just like a traditional drug court or traditional DUI court, where they do get referred and they do use all of their other resources. And that really, the effects have been beyond what I even could have imagined. I mean, when you talk about a 2/3 reduction in filings in the judicial district we're doing it in, along with 50% reduction in collisions, and then we're going to get the cost benefit study sometime shortly after June this year. But the one thing, accountability wise, we need to measure what we're doing, and those kinds of studies are important for us to evaluate how we're doing and be able to sustain ourselves moving forward. So courts should be doing that. I'll leave the second question to my esteemed.
I do have just one follow-up.
Okay.
Back in the day when I was on the municipal court, second time offenders had to do like a 1-year program or 18-month program, SB 38. I mean, does that still apply for these statutory?
Yes. It's 18 months long,
18 months, yes.
DDP, and it is still required. And it's also required for licensing for DMV. So
Right.
it's not something that I could get, because if I try to ignore it, they're still not going to get a license for DMV. So I try to triage it, take care of the monitoring first, and then the second step is to get them in that program so that they can get their license. But we actually, by doing our court, one of the things we got from a study we had back in 2012 is that we had like 2/3 higher percentage of our guys got their license. So by working with them, we were able to actually help them get their license, but we did use the program.
All right.
And
Right,
Justice
very good.
Moreno, I'll just note that our DUI court, I think there's only maybe 10 or so of these across the state presently. I was surprised that our district attorney was willing to have us create one. It's for 3rd and 4th, so the 4th is a felony. And they see me more regularly than what Judge Valvianos just described. But it's just addressing the alcoholism like we do a drug addiction in drug court. It's just recognizing these folks are fundamentally, they're alcoholics, have wrestled with substance use disorder through most of their adult lives, and providing some tools and accountability to get them on a path toward sobriety. And I've been very impressed with the results I think we're seeing.
Perhaps I could answer or try to answer your second question,
Right.
which relates to resources. This is an area where we have, I think, a real challenge. We simply in California do not have enough treatment resources. Right now, what I would tell you is that where you have a strong collaborative court, you will have a strong collaboration with all of the treatment that exists in your county. The challenge is there is not enough, and there has never been enough treatment. And for example, I'm a strong supporter of diversion. I have over 100 felons. It's close to who should be in the state hospital that have been placed in diversion. The problem is we cannot provide the level of treatment always that they need. And what it will take is similar to realignment, is to pass money down. I have just formed the opinion over the years that we do not need as many people as we have in the state hospital. They could do well in community treatment if it exists, if you had enough of it. And it's basically switching where, just as we did with realignment, where the funding goes. Does it come down to the counties or is it left with the state? And for that population, I think we could make a real difference if there was more funding available for treatment at the local level. But this is a challenge across, and I know you have a member of your commission who is an expert on this from Los Angeles. We're all struggling, but it's not because we can't produce better outcomes. We do produce better outcomes because we're reducing the population of the jails. And that is a heavy cost to the counties on a daily basis. And every time, and I mean, Los Angeles is a leader in this, during this pandemic, our jail, we have reduced it to the level of where it was in 1970. But we have moved all those offenders into treatment and housing. And that takes an incredible commitment from the county. And so a collaborative court is not just judges and their team. It involves a commitment. There has to be a commitment by the county, which we have, to put in county general fund dollars, as well as all of their AB 109 and other dollars that they have into the treatment that is needed for these offenders. Because if you just release them to the streets, you go nowhere. And so you have to have the programs there and the housing for the offenders. And we just don't have enough of it in California.
Thank you. Dean Richardson, I think you have a question.
Okay, can you hear me?
Yes.
First, I just want to thank all of the presenters today for both the testimony that you just gave, but also for the documents that you presented to us. And what all of you are doing is so wonderful. And that leads to the question that I have, because it was hard for me as I'm both listening to you and then reading your materials, not to get down into the weeds of all the questions I have about each of your collaborative courts, but rather to put my hat on as a member of this committee to think about what are the most effective recommendations that we can make as a committee that can do, and now I have a number of things. One, provide you and these collaborative courts with the most freedom to innovate in this area, because you're all doing different things and there are costs and benefits to all that you're doing. And it seems like one of the things we want to do is put something into the penal code, perhaps, that expands the options that are available, including, I think this was Judge Manley that you had in your material, having judicial discretion with some of these collaborative courts is so important, it seems to me, both in your testimony and in your written materials. So what suggestions do you have for what we can do to increase innovation and creativity? The second question, which is somewhat related, is there anything we can do as a committee in our recommendations to increase the number of people that are eligible to participate in these programs? So one of you talked about the misdemeanor versus felony distinction with some of these programs, and it strikes me as a result of over-criminalization, there are many felonies that could just as easily be misdemeanors, right? And so a felony restriction in some ways could be an arbitrary restriction when we could actually broaden the number of individuals who have the benefit of these programs. And then the third question, and then I'll stop here, I promise, Michael, is the third question. The overarching question I had of all the proposals is I'm wondering about the data of the people who participate. Like, do we collect data currently of gender, of race, of immigration status, et cetera? Do we do that already? I just don't know. Do we mandate that at all in any of the code sections that we have? And if not, would it be helpful to have something in the penal code that also requires data collection along these metrics so that every year we can take a look at the impact on different communities of your collaborative courts? So those are the questions. I'll leave it there for now. And thank you again so much.
From my perspective, I would encourage thinking global. The approach that we've taken, I call it the community supervision court. And in my county, it's really just 2 judges. It's me and one other judge. And then we process kind of all of this stuff, including that stuff. So when people think they're eligible, they get sent to that court, and then that court can use all of the evidence-based tools. So we can screen people and get all the people that are eligible in. Also, I think, from my perspective, it's important to look beyond just substance use disorder or mental health disorder and into cognitive behavioral stuff. For instance, my DUI court, we're huge. I had over 1,000 just in the DUI court at one point. We're down to 300 now because 70% of my repeat offenders weren't high substance use disorder needs. They were just antisocial thinking needs. So they were people who could stop anytime they want to. They just didn't want to, and you weren't going to make them. And so dealing with that population is really, really huge. You can save a whole lot of jail time working with that population. I personally think the judge is actually more effective dealing with that population than the others because they need that line. The other judge in the country that's doing that, Judge Davis in Missouri, is doing a model with everybody. We were on a panel and she got up and she said the same thing. I think I'm most effective with a high risk, low needs person because that's the one that's fine, and they need the structure that the judge actually brings the most. In terms of data collection, we should be doing it. Almost any federal grant you apply for, you get, requires you to have an evaluator, requires you to have the data collection. And actually, if you go to the conference, they'll say the single most important piece in terms of value, in terms of your success, both recidivism wise and saving money wise, is collecting data, evaluating your data, and adjusting your program based on your data. It should be part of every program that we're doing the data collection. To me, the only way to justify keep doing what we're doing and show it's not a waste of money, or in a worst case scenario, even what the researchers call contraindicated, making it worse. The way to do that is to collect your data. It keeps everything above board, and you just have to be willing to look at that, evaluate back based on that, and then make some adjustments.
If I might, I just wanted to, I know this is not supposed to be a pitch for funding, but if there is a pitch for funding, I would say that for the public defender, the district attorney, probation, if you can incentivize greater participation in these courts and growing these courts, if there were greater grant funds available. I saw when I was the head of the state district attorney group, any number of teams and programs and all that were put into place because there was robust grant funding. And I think that having it where it's understood to be something where, because I get some pushback even from my public defenders because they're stretched thin. These are very labor intensive courts. They believe in the mission. However, at the DA, I get some of that pushback as well. I'm fortunate that I have Lee Seal as our probation chief, who's a real visionary. He offers up bodies without any specific funding for these courts. But to me, beyond any statutory enactments and more robust treatment resources, which I agree with Judge Manley completely, I'd buy off the attorney offices with some grant money. Thank you.
Assemblymember Kamlager.
Great, and I just want to thank all of the panelists for your vision and for your participation. I too have a few questions, some of which we have begun to talk about, which is cost and the scalability of these courts. You know, I represent Los Angeles. We have a collaborative court system down here, but quite frankly, it's the pet project of some visionary judges. And when I asked them about their funding, they said that they had to find ways to fund it from within their budgets. And I, you know, have some questions about that because it's really sort of at the direction of the person who's the supervising or providing judge to say, this is something that I'm going to continue. So how do we sort of step out of that? And I guess you can't if you don't have the data that affirms that they are successful, but would sort of like you all to answer a little bit more about the costs that it takes to run your courts. I think Judge Lavianos, if I'm saying it correctly, you said it's just you and one other judge. And so many of these courts are also very small. How do you create buy-in with the other participants and stakeholders to be a part of this? Other judges, other DAs, other prosecutors. I mean, you can't do it all on your own. So that's the one question. Judge Manley, I think I love you. I love all of the suggestions that you were offering. It's great to have ideas and recommendations on what to do and how to add some vibrancy and flexibility in the penal code. I'm also incredibly interested in additional recommendations on what to take out of the penal code. I mean, when you have Steve Cooley saying that the penal code is too thick, then that should give everyone some pause. And then the third question is, you know, how do we sort of identify and synchronize outcomes between the courts and between our DAs and our prosecutors? Because I oftentimes believe that people are working at cross purposes. And if the goal is to, and the court system is a workforce like any other, just like the DA's office, just like public defenders, just like probation. And on the one hand, there is a need to continue a workforce and to have folks have jobs that they can show up to and do every day. And on the other hand, there is a fundamental philosophical existential desire to minimize the traffic in the courts for so many of these ancillary issues so that we can get about the role and the job of treatment and success. And so how do we, what are ways that you all are thinking about or can recommend to us that would kind of synchronize these outcomes so that we don't have a system working at cross purposes?
I'm just going to jump in for one moment because of Los Angeles and to make my fundamental point. Your mental health courts have grown in the focus on mental health in part because your DA, Jackie Lacey, took on that issue robustly. And you get an ally like that with some of those excellent judges that you have in your county, like our colleague Judge Bianco and others, that is a force multiplier. And so that's my point in terms of, you know, you want to expand this to more conservative counties and to, it can't just be a feature of more progressive counties that embrace collaborative justice. That's why in Sacramento, we're kind of a purple county, I would say. But our law enforcement officials run for office as tough on crime. And so to grow these courts, you have to find a way of a meeting of the minds if you want this to be done in a robust way. Because the plea bargains, most cases, 95% of cases at least, are by a plea bargain. You got to get the DA or your city attorney to be making offers that take into account treatment. And then the public defender will jump on those offers and the judges will go along with it. But if you try to work around the prosecutors, you're just going to keep getting a small slice of what it is you're trying to accomplish. Again, I don't say that because I guess I have my background being that. I think also the reality of understanding what a lot of counties look like in this state from my tenure in different positions. Thank you.
I just add that in my long experience, the court has grown to substantially because of the strong support of the district attorney, the strong support of the county, and to me, we often forget what I ask again and again, why aren't courts, collaborative courts, since I've been doing this so many years, why aren't they growing? And one of our main issues is within the bench itself, the courts, and it varies from court to court. What I have found over the years is that when you can gain the complete support of the bench, that this is something that makes a difference in people's lives, is a better outcome than just sending, as Judge Brown said, doing the numbers and then giving the sentence, that this is a better way to do business, then you can grow your court. I mean, we are now roughly 8 to 10% of the judges of my court are doing collaborative courts. That's a dramatic change from where we were 20 years ago. The strongest supporter is the district attorney and the public defender. Right now, during the pandemic, releasing people from jail, it is all collaboration between everyone. There's no arguments. And it's because everyone comes to see that this is a better way to do it. The research supports it. The challenge with collaborative courts is they are all so small, and we have got to grow them. And one thought I have, and I know, and I do not speak and never have for the Judicial Council, and I would never suggest what the legislature should do other than what I'm doing now, which is I think that in the funding of courts, some consideration should be given to those who are willing to go beyond our traditional role and do this kind of work. In some way it should factor in. Because what I found, and I go back, Senator Byrd, many, many years ago, when drug courts were first funded, we gave $40,000 to each court. And as Judge Flaviano said, suddenly we had drug courts in 56 of the counties. So I think that you have to give incentives to bring people together. And I spend most of my time trying to incentivize stakeholders who don't want to do this to do it. And I think it's something that can be done. It really can. And the number of judges who are doing this work now or who have done it over the last 10 years is phenomenal. I think if you took the entire California judiciary, you'd be surprised to see how many judges understand all these principles. And I think what we need is somehow to push us to get bigger and serve more people.
So I'm going to jump in here for a second, because I think a lot of the questions that have been asked have revolved around these questions of how do we expand it. And I'm not naive. I understand that these are expensive and funding is always a good way to incentivize governments to do things that we want. But do any of you guys have ideas beyond giving more money to DA's offices or courts or whatever that might incentivize expansion of these programs? Right now, it's my understanding that all of these courts exist at the agreement and whim of the counties and the county DAs and the agreements. There's nothing in statute that creates them, establishes them, creates any consistency across the state? Do you guys have any ideas of things that we have specific authority to make recommendations over that might help expand what you guys are doing?
Absolutely. I would focus on, well, two things. I had a great deal of success getting our judges to buy in and send people to our collaborative courts. We have over 1,500 in our collaborative courts totally in San Joaquin County by convincing them to divide the criminal case into two parts. From arrest up until initial sentence. Let the traditional system have it. I don't tell any judge how they should sentence. So I deliberately did not intrude on that. Let that process play out. Then once, as part of that sentence, we offer enhanced supervision. So what collaborative courts do is supervision that's beyond the normal supervision that they're getting for other courts. So we offer enhanced supervision. So it really kind of eliminates that battle between the traditional and the people that want to do it, because if the traditional system handles the case up to sentence, and then you have this couple other judges that handle the case after the sentence and work with probation and work with parole to make sure it be effective, it has been a really effective model. I've got a whole lot of buy-in from my judges. Obviously, we have like 1,500 clients. Another way to do that would be
Just to clarify for a second. So it's part of the sentence. So you're convicted, and then before the sentence is imposed, you're sent to the collaborative court?
Yes, they're more willing to have people evaluated and be part of that, because they know I'm not going to tell them to reduce the sentence or cut the sentence, or I'm just going to let them take care of that. And then I make our resources available. So that has got us a lot of buy-in. The other place where we're getting the tremendous amount of expansion is the supervision violations. Every violation of probation, parole, community supervision comes to my court for an arraignment on that violation. First violation, I'll probably just let them go back to the agency, give them a second chance to try to report and do what they need to do. But when they get to that second or third violation, we're going to screen them, we're going to assess them, we're going to refer them, and we're going to put them in. So we're going to catch them before that next offense that comes after that. And in that supervision violation context, there's been almost no resistance, very little resistance to the use of collaborative courts in that expansion. So this area of probation, community supervision, or parole violation, and having them be evaluated at that point and then screened and put in has been an area that has allowed us to tremendously expand. And then, like I said, we have the two tiers. So the other thing in terms of expansion is to look at not just dealing with the high substance use disorder folks. That's an artificial limit. There are a lot of people out there that are high risk, low needs, that have antisocial thinking issues. The courts can be very effective working with probation. Those same techniques that you use in the traditional court model work very well on that population. So you can be really effective at working with probation. And if you actually do it right, you're stopping them before they get to the high substance use disorder point, and it's much more effective. So my DUI court, where I have two tracks, the people who are in my track one, which is they don't need treatment, that's just monitoring, these are just my antisocial thinkers, they are 80% of my population, 20% of my costs. So I'm able to handle them earlier, much more efficiently by focusing on the antisocial thinking and breaking that pattern before it gets to the high substance use disorder point.
We have about 10 or 15 more minutes left with this panel. Judge Brown, do you have thought about this?
I would just say, I don't have a ready answer in terms of what the statutory schematic could be to necessarily increase the numbers. But I do think that probably having sentencing laws make reference to collaborative courts. And it might be that, you know, when a diversion statute's being passed, there's some acknowledgement that there's also maybe a collaborative court in that same field, and how do they interplay with one another? I mean, like, you look at just drug cases right now, you've got PC 1000 diversion, you've got Prop 36 under 1210.1, and then they may end up in drug court. I've got that whole continuum where I am in Sacramento. I have all those. And they don't all speak to one another. So I do think that in some ways, looking at some of the key areas that the legislature, policymakers want to focus on, like drug addiction, like serious mental illness, and look at sort of a continuum of approaches. And maybe you make collaborative court look somewhat attractive, sort of being a gun to the head of the stakeholders that, well, it's going to be this diversion unless you have a collaborative court. And if you have a collaborative court, you can route the person over there. I don't know. I don't have it clear in my mind, but I do believe that it probably should be something, if you're going to do something in statute, to recognize you have a lot of things already in place in statute relative to the very types of issues you're trying to get to, and figure out how to fold in. I'll just give a quick example. When PC 1000 was converted to post-plea, which has now been undone, but we had sponsored that bill in the DAs, we created an exception for collaborative courts if they had a pre-plea diversion court, because the LADA wanted that exception. So the statute actually spoke to, if you have a drug court, there's an exception to this change in law. So I think there'd be ways, if the policymakers and committee are mindful of, okay, is there a way we could cross-reference into a collaborative court, even if you're not mandating the collaborative court, if that makes sense. Thank you.
No, that does make sense. Judge
You know,
Manley, you
one
have
thought I would add is that you might, I suggest you take a closer look at realignment and mandatory supervision. Now, I was very involved in that process. I was very interested in it. What I believe in mandatory supervision, you can split a sentence, so much jail, so much supervision and treatment and so forth, but it required and suggested that the judge should be making these determinations after listening to everyone as to what should take place after the time had been served. And it seems to me that what has happened is, instead of that taking place, we've gone back to the old system. And I'm really, and you know, I know there's a strong opposition to it, but I think when you mandate that the court must be involved in making determinations, suggesting plans, approving plans, ongoing supervision, when you mandate that, we do what we're told in the courts. And I do not like to ever suggest that we should be mandating the courts do more than they're already doing, because all the other judges will be very upset with me. But I do think that it is a way to grow if you carefully do it. And even if you, for example, I'm working now on primary caretaker diversion, and we're trying to get a program going, even in these times. But there is no mandate. You know, it is all voluntary. And that's a hard thing to do. So I would just suggest that you look at that, the way that system was set up, and to how it could be changed or altered to have the court more involved in monitoring, just as the three judges on this panel are doing now. Thank you.
Does anybody else have any further questions? Yeah, Senator Skinner.
You're on mute. You have to
Okay,
unmute.
I'm
Yeah, you're up.
unmuted now.
You
Okay.
guys-
I appreciate the discussion we've heard, and a lot I take away from it is that we have good diversionary courts, we have good collaborative courts and such, but what we seem to be still in need of or lacking is the enough community-based programs to support that court activity. And Judge Manley, everyone, all of you referred to, especially the mental health and diversion in the mental health programs. So I know that it's not necessarily the courts, the community programs are really more something that counties and the legislature and all have to either fund or put together. But I wondered if you all wanted to express any opinions on experiences, or if we were to, for example, if this committee were to recommend that needs an influx of investment, then are there any guidelines or particular scopes that we need to pay attention to make sure that it's effective?
Well, I think if you were going to do that, the question to me is not whether or not it's going to be effective or whether we need guidelines. It's that we simply don't have the treatment at all. What I would suggest is that you focus on specific, if you want to mentally ill, whatever it is, the target population, and then we need funding to be able to meet that need. In other words, the problem I see is that with diversion, which I strongly support, mental health diversion, we are trapped because the statute says it's based on existing resources at the county level. And so I would take something you've already agreed on that is important, like mental health diversion, and start funding the alternatives to the state hospital, and just do it in a way that is not just 2 counties or 3, but all the counties. And I think you would see that you really can make a difference. We can do a better job than we're doing now. But the way I would do the scope, I would confine it just to something you've already put into effect, like mental health diversion, where we simply don't have the resources. And start there, then use that to move on to other areas.
I would agree with that 100%, and focusing on the counties, I think, is critical. If the counties are responsible for developing this level of care, and the counties are the only one who can do it. So getting the funding to the counties to let them develop a system of care. And we've got a great behavioral health director who's in the process of doing that, and my mental health court is benefiting greatly from it. So if we take the people who are responsible for developing the level of care and we work with them to get the funding to put those resources in place, to me, that's the best chance.
And I absolutely agree that having resources for community restoration program, Senator Skinner, into the panel would be very valuable. It is very odd sometimes when one is having to remand someone into custody just to go get treated and then wait to go to the state hospital or to a jail-based, community-based, jail-based program for restoration. I mean, some people, that's fine, but others, I think if you built it, we would definitely have good numbers of people who would benefit from a community-based restoration. I think sometimes confusion arises on when we say diversion. In my mind, I almost look at it as it's a realignment away from state hospital restoration. Whether the case gets fully diverted under PC 1000 1.36, or whether or not it gets moved to a mental health court, or whether or not it's just a regular old probation grant, those are almost 2 separate things. And that really, I think, I very much support the idea. I think there would be a lot of support for having sort of realigned some of the restoration functions to the community if we had funding to do so.
I was wondering
Senator, if I might, I also want to give one shout out as well, because I had some concern about the diversion law and the scope of it and all of that. Again, I have to just work through my old ways. But what I would say is this: what you have accomplished is you have made it where the defense bar focuses on this issue like a laser beam. No longer do I see defense attorneys who are very busy not necessarily thinking about, does my client have a serious mental health issue? And now it's almost malpractice that they don't think about it, because the person might get diversion or mental health court or some better probationary offer. And so our treatment providers are getting huge numbers of referrals. My behavioral health department has increased 3-fold the number of their staff assessing people for mental health illnesses and linkage to services because of the diversion law. So I just wanted to kind of share that.
No, that's actually extraordinary, very interesting, because it's a way that we can change, the way that a statute might incentivize, or maybe not directly incentivize, but change behaviors. And I think that we should look at that. We're almost out of time. I was wondering, as you have been more deeply involved with this than others, are there other states or other programs that you guys have admired and that maybe we should look at as we begin to look at other models around the country and perhaps the world?
I think the state of New York has done some incredible things, and I think it's a good state to look at. Washington as well, in the West Coast. I think they're two model states that really think outside the box.
And if you want to send me to Hawaii to review the Hawaii courts, I can report back to you, Mr. Romano.
Yeah, I'll go with you. Sounds good.
That the state of Missouri is doing a multi-track model of the quadrant, where Judge Davis has a track for each of the 4 quadrants. And Judge Peggy Davis in Missouri, and she's being researched by NPC Research and getting a lot of good attention. So she's evaluating them. Then they got a different program where where they go in the quadrant, and they're getting a lot of good results. So Missouri, with their multi-track system, is doing very well.
Well, thanks. We'll definitely take a look at that. Thank you all so much. Like I said, this is just the beginning. I promise we'll be, no good deed goes unpunished. So I promise we'll be back in touch with you. We'd really like to bounce our ideas off of you as we begin to develop. And please, if things come to your mind later on that you think that we should look at, please do not hesitate to reach out to us. I believe you're in touch with our staff. Thank you again so much for your time. We really appreciate it. Super helpful. We're going to take a 5-minute break before our next panel. Thanks again, and we'll see you back in 5 minutes.
Goodbye, Senator Burton.
Thank you very much.
Okay, I think we're back, or I'm back. I hope everybody else is back. Tom, can you make sure the panelists for diversion are activated? Tom, can you hear me? Tom, can you hear me? Can everybody else hear me?
Yeah, you're not on mute.
All right.
I don't know where Tom is, Mike. I'm texting him now.
Okay. He says he can't hear anything.
What did they?
You can unmute it. They're just making sure everyone's here. Okay. John's sitting there so they can see. Yeah.
Okay, looks like everybody is here. D.A. O'Malley, Judge Lowenthal, Mr. Adams, are we there? Great.
Aye.
All right, awesome. Thank you all. This next panel, which is actually a good segue from what Judge Brown mentioned at the end of his presentation, is on diversion programs that may help someone to avoid criminal prosecution in the first place, primarily by completing some course of treatment or other conditions. Today, we will hear from DA Nancy O'Malley, who's the District Attorney for Alameda County and current president of the District Attorneys Association. Thanks for joining us. Judge Daniel Lowenthal from the Superior Court of Los Angeles County, and Anthony Adams, who's a public defender in Mendocino County. Thank you all for joining us. DA O'Malley, if you don't mind kicking us off for 5 minutes.
Yes, thank you. Thank you so much for the opportunity to speak with you today. I am going to talk about diversion, both pre-charging diversion and post-charging diversion. There are several examples around the state and very impactful programs that are providing alternatives to incarcerating people. And of course, that's dependent on the crime. But in the end, at the conclusion of the diversion program, that the result is generally a dismissal or a reduction of a felony to a misdemeanor and ultimately dismissal. This becomes really important because, as we know, criminal convictions can be a barrier to someone being able to move on in their life. I will say that the programs that I have, as well as many around the state, are producing very positive results with outcomes of sustained success, which I think is really a critical point, is that it's not just while they're in the before us in the justice system, but when they go on to their life. And for many of the people that have gone through diversion, we never see them in the criminal justice system again. The programs are not necessarily outlined in the penal code, but is actually being implemented by partnerships between the court, the district attorneys, and justice partners. When a crime occurs, of course, depending on the severity, it's in the best interest of those of us with the authority to reduce reliance on incarceration, to invest in programs that address core causes or the core needs of an individual who finds himself or herself justice involved. We have a good chance, a very good chance, to provide those resources and to create the opportunities that may have been lacking for the individuals, or maybe they just missed out on those. I see our work, particularly in diversion and the collaborative courts, as a positive investment in the future of these individuals who have become justice involved. In a cost-benefit analysis, there's no question that diversion wins out over incarceration. Let me also say that diversion and collaborative courts are not just for those with low-level misdemeanor crimes. In fact, there are programs, I have programs that are for individuals who have been repeatedly justice involved, some for very serious crimes. And our investment does not necessarily start or stop with the first-time offenders. And I think that too is a critical investment that we're making, that it isn't just for first-time offenders, but we're trying to stop people to create help them find a different pathway than continuing to commit crimes. Of course, it's important for the penal code to outline processes such as diversion to ensure that the justice partners and the participants understand basically the rules of the game. But I do think that the penal code has continued to grow considerably. And there are sections that contradict each other. I think Judge Brown talked about it earlier, about the contradiction between drug court versus PC 1000 versus Prop 36 drug programs. So I want to give focus today, however, to programs that the penal code that are absent or silent in the penal code, because I believe that in many respects, these are very important programs that created oftentimes, and let me say, I'll speak for myself, but for the other offices as well. I know for myself, we've created several programs with the consent of the court, and of course, the partnership with our justice partners on the defense side, the ability to create programs that are not defined in the code. And it allows the district attorneys and the counties to be more progressive, to be more proactive, to ensure safer communities, fewer victims of crime, and to reduce crime. As you have seen in the materials that I presented earlier, my office has created programs that have reduced and in many respects eliminated reliance on incarceration. But I want to make a really strong point. It isn't just avoiding jail. If it was just avoiding jail, we could just release people and we'd likely see some of them again. The programs that we have, these diversion programs, are programs that are designed to treat each individual as an individual. That's a break from traditional criminal law. The other thing is that with the individual, we assess their needs, we provide them with skills and avenues to avoid being involved in crime, and I highlight the role of mentors and peer support specialists, which I think are critical for the future successes of diversion or collaborative courts. People who have lived experience who are now committed to helping others to get through that experience. For those who are prepared to engage and it recognizes and creates pathways for them to achieve their potential. So I have presented to you a booklet that outlines the collaborative courts I have created in Alameda County. Very few of these courts are contained in the penal code. And I'm proud to tell you that even through this COVID-19 time, those courts are all still operational. We're just doing it remotely. But it also speaks volumes to the ability of justice partners in the court to come together to create programs that are going to be cost effective, but in the human standpoint, they're going to be tremendously effective. I want to just highlight 3 areas very briefly. The first one is pre-charging diversion. We have 2 programs. One of them we call PES, and that's for people that do involve themselves in lower level misdemeanor behaviors. Oftentimes, it just takes going to an awareness class or having some type of awareness intervention. Charges are never filed against those individuals, and we have a 90% success of never seeing those people again. The second one, which is our newest one, we call 3D, which we are deflecting people away from criminal justice. We're deferring them into other disciplines like behavioral health or mental health. And if they do result in charges, they're being diverted into the programs. And that's specifically to focus on people with mental health and substance abuse. In both of those circumstances, the arrest becomes a detention only. And that's significant because that drops off their record. So again, not a barrier for their ability to get housing or to move beyond this experience. The second area is when somebody's arrested and charges are filed and they are then diverted into a program. In my county, we have early intervention court, which really does individualized care to make sure that we are giving what the individual needs to be able to move beyond. And I will share with you that I have over 200 people that have participated. We have only charted 10 who have left the program. And our mentor diversion program, which has been around for more than 20 years, working with young male offenders, has an 80% success rate. Again, bringing mentors into it, individualized treatment, and giving them support that they need to move on. And then the last area is reentry court and our Alameda County Justice Restoration Project. Both of those deal with people who have criminal convictions, some quite serious, who are now back in the criminal justice system. With Justice Restoration Project, this is a project, a pay for success project. It is funded by foundations. It's being evaluated by an independent evaluator to see if the way we are doing business with ACJRP is different than the traditional pathway. And we have a control group and we have the participant group. And at the end of this, we have 150 people who are being evaluated. And so far, we're seeing the results are positive for reducing their recidivism and for them moving on.
Terrific.
I just want to say that, go ahead.
I want to keep in mind on the time. We'll definitely come back to make sure that
Okay.
everybody gets to. I also want to say we're particularly grateful to have you here, DA O'Malley, just as somebody who's the head of the DA's Association, to stand up and really highlight some of the things that you're doing in Alameda County. For Judge Lowenthal, who's next, and Mr. Adams, we're especially interested, of course, in specific reforms that you might suggest to the penal code to enhance the programs that we generally think that you think are working, or conversely, areas of the penal code that might be getting in your way. So Judge Lowenthal.
Thank you. So I'll note that judges may only offer diversion when specifically authorized by the legislature. And as DA O'Malley indicated, there are many DAs who have profoundly impactful programs. DAs don't need that specific authorization to have programs, but they don't exist in all counties. And in the counties in which they do exist, they're somewhat narrowly drawn. As a result of that, judges have, for many years, sought authorization from the legislature to be able to divert misdemeanors. Based on the models that are in existence in many other states, the legislature did confer judges in LA County with the discretion to divert most misdemeanors in a pilot program that was in existence for 3 years, 2015 through the end of 2017. The participants were required to comply with the diversionary terms and conditions that were specified by the diverting court. Because misdemeanor sentencing, as everyone knows, is already entirely within the purview of the courts, the only change to existing law that the pilot program made, essentially, was that courts were spared from the requirement that they enter judgment against participants. Because ostensibly, a judge would impose the same terms and conditions, whether she was required to enter judgment, as she is traditionally, or not, as in this pilot program. The LA County Superior Court created a code to track the results of the cases. We granted diversion in 5,600 cases using the code. We actually think that the number of cases in which diversion was granted was much higher, but there were many judicial assistants who didn't use the code that was created, and we were unable to count those cases. Of the 5,600 cases that we were able to track, we had a success rate of over 95%. That's over 95% of the participants successfully completed the imposed conditions and then left their encounter with the justice system without a criminal conviction. This program dramatically eased court congestion. In the 3 years prior to the enactment of the program, fiscal years 2012 through 2014, the Los Angeles County Superior Court averaged 3,193. That's 3,193 misdemeanor trials a year. Those are traffic and non-traffic jury and court trials. During the 2 full years that followed enactment of the program, fiscal years 2016 and 2017, our average dropped to 869 trials a year. So 3,193 to 869, more than a 70% decrease in misdemeanor trials. So of course, we highly recommend that the program be made permanent and implemented statewide in either a pre-plea or post-plea format. It's just a common sense approach to handling low-level cases, and most importantly, spares participants from a lifetime of debilitating collateral consequences that, of course, are caused by a conviction. Thank you.
Thank you. Very interesting. We'll come back to it, I'm sure. Mr. Adams.
Good afternoon. Thank you very much to the chairperson and the members of the committee for this opportunity to share with you some of my thoughts. Let me see if I can just jump right into sort of the call of the question. I've provided for the committee some recommendations for things that could be changed. I want to broaden on that a little bit. Having listened to the prior panel, there's something that I think that the committee may want to consider, and that is creating a new presumption in the penal code towards diversion. There is a number of presumptions that the law already has in place. For instance, the presumption that a person is probation eligible unless there's a disqualifying factor that then makes them presumptively ineligible. If there was a presumption under the law that a person was to be at least considered for a diversion program, there would at least need to be some finding of facts, some declaration from the court about why that person is not an appropriate candidate for diversion. I think that would incentivize the criminal justice partners to really put diversion at the forefront of everyone's thought process as we're pursuing an answer to these questions. Secondly, I think there is a tremendous amount of work that has to be done collaboratively for any diversion program to work. And at least I'm going to speak specifically to the concerns that I believe are echoed by most of our very small counties. Here in Mendocino County, we're under 90,000 people countywide. We have a very, very finite number of resources available to us. The county is the principal provider for most of them, but the county can elect not to participate in our collaborative courts and our diversion programs if they don't think that if they're either not fully educated about them or they just don't think they have the resources. But I think that does a disservice to our greater community. The penal code could reflect that the county is required to at least provide some basic infrastructure for the work that is going on in diversion courts. Let me give you an example. Here in Mendocino County, as you read, we have what we call the behavioral health court. The behavioral health court deals exclusively with people who are in the criminal justice system principally because of some mental health issue that they may be having. We want to take those people out of the equation from the traditional criminal defense, because if we can't get to the underlying issue of their mental health concerns, we're never going to be able to fully rehabilitate these individuals. That oftentimes requires us to have the participation of our mental health department or the substance use disorder treatment team that the county has, or even oftentimes the sheriff's office, who has jail staff, that has medical staff that are seeing and treating these folks in real time. By requiring at least the participation of liaisons from those respective agencies, we have a system in place where we can reliably trust that all of the partners in this system are working together. Another area of the penal code that the committee may want to consider is the 1001.36 diversions. These diversions were an incredibly wonderful tool to the defense bar. I think that they provide an excellent mechanism for people to be removed from the system in an early stage and treated in a manner that is more reflective of the underlying social issue that is going on, rather than simply as a strict criminal defendant. There is a small barrier to that, though, in that the defense is required under that code section to have to be the one that gets the mental health evaluation conducted to provide evidence to that court. This is probably fine in a lot of larger counties where there's more access to resources, but in small counties, and I'm going to speak specifically to one of our sister counties, Lake County, where you have a contract public defender team, where they don't have a sustained office. Oftentimes, they have no ready resource to be able to do that. So if I'm a contract public defender and I'm assigned, 50 or 60 misdemeanor and felony cases this month, I may not have the resources to be able to independently go out and hire people to do this. I think the 1001.36 be amended to afford the opportunity for a prima facie showing to a judge that there's a mental health consideration, and then authorize the courts to then utilize the court's funds, if available, to hire somebody to conduct this evaluation. I think that's the starting phase of a much larger conversation. And again, I want to thank the committee for this opportunity.
Thank you very much. These are really helpful. I want to start off with anybody have any questions from members?
Yeah, I do.
Yes, Justice Moreno, yeah.
This is for Judge Lowenthal. What's the current status of the misdemeanor diversion? It seems like the pilot project was very successful. Are you getting any buy-in from DAs now that it seems that prominent DAs are now supporting a more, it's called progressive approach towards these issues?
You're right. I think that, so after the program sunset in 2018, there has been a lot less resistance than there traditionally was, especially when we were fighting for the program back in 2014. I haven't actively sought buy-in, but the sense I have is that there is much more openness.
But you would welcome the support of this committee, I would assume.
Oh, absolutely.
So I want to follow up on that. It just sunsetted and there wasn't nobody took it up, or it wasn't then rejected later on.
Actually, Senator Skinner did, and my recollection is that she inserted it in the budget, and I think there might have been opposition from the LA County District Attorney, but for whatever reason, the governor pulled it.
And also to clarify on that program, one of the things that I think, as my understanding is correct, is that made it quite different from both the collaborative courts and diversion programs that we've been talking about in general, is it really gave the power to the judges to make these determinations rather than acquiescence from the district attorney. Is that right? The district.
Right. And we, absolutely right. And we viewed it as complementing the DA programs that were in existence. But yes, buy-in from a prosecutor was not needed. A judge was able to confer this over a prosecutorial objection.
Thank you. Yes, Senator Skinner.
I now, Judge Lowenthal, thank you very much, and also Judge Moreno, because I was going to ask a similar question as to, because I could not recall whether my office's attempt to get this continued was successful or not. But Judge Lowenthal, does it require us to do something statutorily in order for it to continue?
It does, because there are several cases that say that courts cannot, for rehabilitative purposes, dismiss a case via 1385.
Right.
And so that's what it comes down to. So it's as easy as tweaking 1385 to say that dismissal for the purpose of rehabilitative purposes is not unacceptable, or specifically adding a provision into the 1001 series.
DA O'Malley, I hate to put you on the spot, but can you respond?
You have to unmute.
Sorry. So I think that there's the climate change of relationships between the district attorneys and the courts and the defense bar in terms of creating programs is very different than it has changed pretty dramatically in the last couple of years. For one, we're seeing these diversion programs be very successful and produce successful outcomes. And so I think that there's a concern that that somebody who's a serious offender might get dismissed because of because they're going through a diversion program. But I think that part of the program and part of the, obviously, I think the success of the program is when the court and the two justice partners sit down and work through the details of how it's going to work. And I'm assuming, Judge Lowenthal, that occurred when you started the program in LA, that everybody came together and put together a program, and then it was very clear what the buy-in was from the different parties.
To some extent, but you know, there are tens of thousands of types of cases. There wasn't an inability, especially how burgeoning LA County is and how burgeoning our penal code is to find a one-size-fits-all that really was workable.
Well, in listening,
go ahead.
Sorry.
Go ahead, DA.
I was just going to say, in listening to the panel before with the judges talking about the success and the increasing success and expansion of the different collaborative courts, the drug court, the mental health court, these are courts that DAs are involved in. So I would expect that there would be a different, more collaborative conversation around legislation that was previously did not succeed.
Senator Burton, I see you have your hand up. Do you have a question?
Oh, yeah, I wanted to have Judge Lowenthal say hi to his folks for me.
I will.
Served with both of them, loved them both. My concern about the diversion in my first time I ever came in contact with it was over domestic violence 100 years ago. I think I was in the assembly at the time. And one of the concerns that I've had sometime is the DAs could use that as a leverage with somebody. Say, well, if you go to trial, and these are my words, not theirs, you know, you could get screwed. But if you take diversion, then you're going to get better worked out. And kind of there was leverage on a defendant to go to diversion, even if he might not have, you know, if he had a shot
not being convicted. That concern has been expressed to me over the years, but I remember it clearly from the domestic violence. And I think it was a woman, and I think she was damn near a federal attorney that came up, and she's the one who lobbied the legislature on the issue. And I had to have several lunches with Gloria Allred so I could get her off my ass for not supporting the bill. But that's a concern, and I don't know what your experience has been. As I say, that was a hell of a long time ago.
Typically excluded from the category of misdemeanors that were eligible to be diverted. So we did not, the only diversion of domestic violence cases that has occurred have been those crafted by district attorneys.
Okay. All right, thank you. Again, hi to the folks.
Definitely.
Yes, Assemblymember Kamlager.
Yeah, thank you. And Senator Burton actually stole a portion of my question. So thank you so much. Of course, it was much more colored than how I was going to ask it. But to expand on that, I wanted to know from you, Judge Lowenthal, to what extent are the diversion programs that you're talking about potentially frustrated by opposition from DAs? And or what are some of the maneuverings that happen for folks to kind of get around it? And to Senator Burton's point, what are the safeguards that actually prevent pleas for convenience?
And do you mean frustrated by the DAs during the political process of the bill being considered by the legislature, or do you mean the implementation of the actual cases?
The implementation, yes. They frustrate us all the time in public safety, yes, but I'm talking about in the courts.
None at all.
And then I have one other question, so I'll get that out of the way, but I think it's for Anthony Adams, so I'll let you answer the first one.
So no frustration at all, because it is the same under this pilot program as an open plea to the court, where a defendant pleads open. They're not negotiating a disposition with the district attorney. The judge is going to impose whatever terms and conditions in a traditional prosecuted case that she thinks appropriate. Under the pilot program, it worked the same way. So if the judge would have imposed a year of probation, it's a year of a diversionary period. If there would have been a petty theft counseling class, there still is a petty theft counseling class. The only difference is that the judge was not being forced to enter judgment. The guilty plea that was given up front is held in abeyance. And upon completion of the year period and conditions imposed, the guilty plea is set aside. And because it was never entered into the system, a conviction never ensued. So this is, open pleas are something that have happened since the beginning of our judicial system. And so there isn't a difference.
May I actually answer that question briefly as well?
Yeah.
So let me, with all due respect to the prior comments, let me tell you what the perspective is from somebody who actually negotiates with DAs before a judge gets involved. There is an extraordinary tendency, at least in this county, for the wildly overcharging of criminal complaints to try to force a resolution. Oftentimes, we get to a stage where, like a preliminary hearing, we have an extraordinary number of charges being based on criminal offense, and potentially more if we go forward with the hearing, which can further incentivize somebody to not want to participate in the system and just take the first thing that can get them out of it. That is a very, very real problem that we face all the time. Let me tell you, the answer to that question in large measure is precisely what Judge Lowenthal has suggested, and some of the members of the prior panel did as well. Providing the judge more opportunities to make an informed, neutral decision about whether somebody should be available for a diversion program or some kind of pre-plea diversion or a collaborative court or resolution, giving them more of that authority so that you're not relying upon essentially just the hope, wish, grace, and mercy of the DA to give that person the opportunity to get out, that would be a tremendous tool in trying to get people out of the system. The bottom line is, once they're in that system and they start to rotate through it, then before you even get to court, you can already hear the DA making the case that, you know, the future behavior is best predicted by past behavior, and you've got this rap sheet that is insurmountable and then is deleterious to our ability to really help intervene with our clients. And I can't overstate how important it is to understand the core concept that the only way to break that cycle is to find the underlying cause of this criminality and addressing it at the earliest possible stage.
Well, so and your response is helpful, because my question to you was in response to what you said about diversion being a great tool for the defense bar, but you said that the defense has to initiate it, and of course the DAs can resist it. And I don't know if you said that or if in my mind that popped up. And so, you know, really sort of wanting to get your thoughts on what kind of transparency or accountability measures could we consider to kind of assure that that resistance is justified?
Well,
when
I
it
think
does come from them?
Well, that's an excellent question, and I appreciate it. And let me just backtrack a little bit. I don't want to be in an adversarial position with such esteemed people on the line. DA O'Malley has done remarkable things in hers. I know Judge Lowenthal's work is remarkable in this. So this is not intended to be a hit on DAs, but I can tell you that there are times when the authority vested in a district attorney is so great that a criminal defendant oftentimes won't listen to reason when you're trying to explain that there is a secondary pathway, but only if you're willing to open plea to all of these charges. See, when a defense attorney receives an offer from the district attorney, we are ethically bound to communicate that offer to our client. Now, we can advise them that this is not a good idea, but we're bound to that obligation to tell them what that offer is. And so if the original charging complaint is extraordinary and voluminous, and they're facing this incredible amount of potential time, an open plea really isn't a viable option for us, because you have to take the entire thing. And so to answer your question directly, my prior comments, I think the greatest way to do that. Let there be a presumption in the law that diversion is appropriate. Let a neutral fact finder make a determination that that's not an appropriate choice after consult with the district attorney's office and the defense bar about what is appropriate. And I think that would create the transparency that you're suggesting, Assembly Member.
Judge Espinoza?
I need a point of clarification with Judge Lowenthal. I want to make sure I understand the parameters of the pilot that was launched in Los Angeles County. You had the authority on your own to divert all misdemeanors except domestic violence and drunk driving. Is that?
There were some other excluded categories: 290 registration.
290 registration.
The battery on a peace officer, possession of deadly weapons, DV, DUI. I think that was it.
Other than that, any other misdemeanor, you had the authority to divert without anyone's permission, so to say.
Right.
Okay.
And it was post-plea, not pre-plea. So it was leveraged by a guilty plea.
Almost like a deferred entry of judgment.
Right. It was a DEJ.
Okay. Great.
Can I just say that? Oh, I'm sorry.
Go, no, us DA.
DA O'Malley?
I just wanted to say that, you know, I think that part of this is when we go into diversion courts or collaborative courts, that the relationship between the defense bar, the prosecutor, and the court is very different. And for those cases that for us, we have misdemeanor diversion, we've got felony diversion, we've got people that have committed serious crimes and are back in with a new crime. The relationship is very different. And I think that that's something that we should really focus on as professionals, that looking at what causes people to come into the criminal justice system is worth our investment. And that's what we're doing successfully in my county and in several other counties, of looking to see what is it we can do to help this person stop committing crimes. And we've got a lot of data. 8,000 people participated or benefited from collaborative court in my county last year. And so I caution us to, you know, I think that Mr. Adams' point about this is not about pitting one side against the other. I think that the key of all of this is really bringing these justice partners together for the good of the person who needs our help or could use our help or could use the resources that we can muster together so that they can move on with a healthy life and a positive life.
DA O'Malley, I think everybody here shares those goals, sincerely. And as the DA in your county, you have an extraordinary amount of control over the process and being able to find those cases and route them in the right direction. As sort of the question that kept on coming back from the last panel is, how can we take a program that's doing very well, for example, in Alameda County, and encourage it through the penal code, either through some presumption or something like Judge Lowenthal? I was wondering if you had specific ideas that the penal code could do to encourage the type of diversion programs that you see are especially effective in Alameda.
So I do think that there was a new penal code section a few years ago, which is, I think it's 1000.12, which allows young offenders to be diverted into after plea. So first of all, they had to plea first to be able to participate. And then they would spend a year in, there are 5 pilot projects, spend a year in juvenile hall, being housed there and participating in programs. We have practically nobody in there. And so my concern is that if we try to regulate it too much about what the steps are, that it both competes with other more open programs, and it means it so that there's nobody wants to go into that program because it's so restricted. And so I think that for me, that when diversion, PC 1000 was first created, was very, very broad and very open. And it gave a lot of authority, and that's a long time ago, that it gave a lot of authority to the court and to the defendants to have the benefit of having their cases dismissed and getting treatment, or just not being in court for 18 months, I think it was in those days. That the encouraging, leaving it, not trying to completely prescribe what steps have to be for a successful program, but rather leaving these openness to the program. I will say Senator Skinner last year had a bill that allowed the court, with the consent, with the agreement of the prosecutor and the defense attorney, to create a diversion program for people who are primary caregivers. And that really brings the court and the two justice sides together to create these programs. And that's, I think, encouraging those types of legislation where it leaves more openness for the counties to create the programs together. And then you heard earlier, there's incentive with money, resources, or other things like that, that could go along, but I know we're not talking about resources, but some ways to incentivize the 3 entities to come together.
Mr. Adams, I had a question. There's a lot of talk in diversion about the advantages and disadvantages of pre-plea, post-plea. Do you have a feeling about that? The way that I understand that the LA pilot program is, you pled guilty and it was a deferred entry of judgment. So you had this kind of a conviction hanging over your head, but then it could be, I don't know what it was on your record during the time of your programming, but I guess it was deferred. So it was
no record. Right, judgment wasn't entered, it was in abeyance.
Okay, so it was in abeyance. Versus, there's never any judgment whatsoever. Do you have a strong feeling one way or another about how diversion programs should work?
Absolutely. Let me tell you, the single greatest tool is anything that we can do to enter into some kind of diversion pre-plea. Here's one of the biggest considerations that we face. We have a great number of people in the criminal justice system who may not be documented citizens. If a non-documented citizen enters a plea, even in a diversion situation, but they have to enter that plea, that is something that can and is used by the immigration services in making determinations about whether or not they should be permitted to stay in the country, receive a green card, whatever the case may be. Anything on the record in that regard has immigration consequences that are severe. So oftentimes that whole category of individual is precluded from participation in any type of diversion program where that's a barrier. So that's one on its own. So that by itself, I think, is enough for at least the consideration of an alternative way of handling things.
Does that sound right to you, Judge Lowenthal?
It does, absolutely. And in fact, the LA County Superior Court requested the pilot program be pre-plea for political reasons. During the process, it got changed to post-plea. But yeah, but absolutely agree.
Assemblymember Comlager.
Yeah, thank you for that. I was wondering if you all could also sort of talk about, you know, the prevalence of upcharging and if that can hinder access to these diversionary programs.
Yes, if I may begin, I absolutely think that's a fundamental problem that we're facing. The DAs have such broad discretion to charge, and rightly so. I don't take issue with that. But there is at least in this county, there's a very obvious tendency towards filing bottlers, things that can be charged as either a misdemeanor or a felony, charging them as felonies as a negotiation tool to then maybe get the person down later on because they're incentivized to try to settle something. And often the settling is something that involves a prison commitment or an agreement to be on probation for a number of years. And that may be something that then closes the door on the ability to engage in a earnest discussion about diversion. This is not always the case, but it happens with enough frequency that I think that there is a disadvantage to trying to hold the two in your hands at the same time, that we want to incentivize diversion programs. At the same time, we want to ensure the public safety. Those things that they make sense, but you can't overcharge while simultaneously trying to incentivize people being taken out of the system through rehabilitative measures.
Well, I would say that.
Oh, I'm sorry, DA O'Malley.
I just wanted to say that, I mean, the prosecutors have an ethical obligation to only charge what they can prove. And so when we say upcharging, it sounds, and I think that, you know, the prosecutors, and I will speak for my office, that we charge what we can prove and what we think the case is. And oftentimes they result in someone pleading to a lesser charge or to a lower charge, not because the original charge was not valid or supported by evidence, but because it's a way to resolve cases. So I just, you know, I don't see amongst my colleagues, to the extent that I would know, but I do say that we are ethical people who should not be putting more charges on just to try to manipulate an outcome. That would violate the ethical standards for prosecutors.
And I would just comment on top of that, much of the heavy sentences that are being are on the table are not the result of prosecutors' decisions, but are on, you know, the legislatures created those punishments in the first place. So, you know, it's one of the reasons why this committee was, you know, it's just as much on lawmakers and voters who enacted certain laws sometimes than just the prosecutors.
Hello, we bear equal responsibility in this maelstrom that we've created.
Dean Richardson.
So most of my questions have already been asked by you, Michael, and by Assemblywoman Comlager. But I do have an additional question just on this recent discussion, because it's really hard, I think, to talk about diversion without talking about some of the issues we've just mentioned. Over criminalization in our penal code that gives so much power to prosecutors and to police to make the arrest decisions. And then we have the, whether you call it overcharging or not, or when we talk about how can we stop people from committing crimes, that has been said a number of times, the thing that comes to mind all the time is it depends on what you mean by crime, right? It's that typical thing we learn in law school, right? Like, is it a crime? Some things are crimes just because we created a law to say they are, right? So people smoke pot all the time. And for some people, smoking pot is a crime. We still have significant racial disparities today in California on who gets arrested for possession of pot, right? Racial disparities that exist, and we say they've committed a crime, but we have a whole category of the population, many of whom we see in colleges and universities smoking pot, who have not committed a crime simply because they have not been arrested or brought to the attention of the criminal justice system. So I think it's really hard then to talk about diversion without talking about all those other issues, which then lead me, I guess, to a question. I'm very curious about data collection. And I asked this of the last panel too, because I don't know, and again, I didn't practice in California when I was a criminal defense lawyer, so I don't know whether or not there's any mandatory data collection of how diversion is used, what prosecutorial decision-making is, what the charges are, depending on whether the gender of or the race or the immigration status of the person who comes to the attention of the criminal justice system. But this might be one way where we can get more information and where prosecutors and defense lawyers can learn themselves whether or not they are unintentionally charging certain people with particular crimes for the identical behavior, right? So I wonder if something like that exists, and if not, how people would feel about that. So I'm talking about like getting data when prosecutors make charging decisions, and then which cases, which defendants get sent to diversion, what types of dismissals are made, just all of this data that would provide everyone with information that we could then use moving forward to determine how we craft these diversion programs and what we create incentives for. So curious about.
Well,
I can answer that.
Oh, okay.
Go ahead.
Well, I was going to say that, you know, data like demographic data is required to be reported by law enforcement. That there was a bill to have prosecutors and the courts do the same, although it became redundant because we were dealing with the same people. But there is a lot of data that's collected. I know for myself, for our programs, we want to make sure we are producing the outcomes which align with our goals. So we keep a lot of data, a lot of demographic data to be able to identify how we're doing and how people are doing going through the programs. There's a very big committee and a big focus of the DAs Association, California DAs, we have a data committee. So we're working with an organization that is working with DA offices to set data parameters for them so that we can capture all of the things you just suggested in order for us to be able to not only show what we're doing, but also to evaluate our outcomes and if we're on track with the goals that we're setting for ourselves. And that is a project that has several DAs. I mean, not everybody has bought into it, but many have. And I co-chair that with the district attorney from Yolo County. And we are working with this, like I said, this national organization to help gather the data for exactly the questions that you just asked.
And if I may add on to that, Dean Richardson, one of the, first of all, I don't think anyone should fear data. It'd be amazing to have as much as possible. The quantitative value of it, though, I think largely depends on how you sort of set up the metrics, because to step off from one of the comments that you made about, you know, whether or not people are being treated essentially the same in a similar circumstance, it becomes a very complicated decision, as you know, having practiced criminal law in the past, to really compare apples to apples. One person's 422 is a very different person's 422, depending on the circumstances of that particular incident. One could be just a basic disagreement between two, you know, romantic partners where it got out of control and one was screaming horrible things and threatening, and it was just the heat of the moment and there was never any follow-up, versus, you know, being threatened on the street by a gang member that if you show up on the street again, you're going to get shot in the face. You know, they're both 422s, but they're very different 422s, and it's hard to know necessarily basic demographic data would really hone in on those differences so that we don't draw erroneous conclusions. I think that would be the real challenge.
I have a data question for Judge Lowenthal. So you said that 90-some% of the people, well, I was very impressed, first of all, the reduction in misdemeanor caseload. My first question is, has the misdemeanor caseload gone up? Number two is, you said a very high completion rate of the programs. Did you also track recidivism rate of people who've completed the program?
Unfortunately, we were unable, there hasn't been enough time to do a longitudinal look back at recidivism. And I'm not sure if we have the capability of doing that. as far as there definitely has been an increase in the number of jury trials. Empirically, I don't know what that is. The Judicial Council statistics for 2020, which will have the 2018-2019 fiscal year statistics, has not yet been released. The moment it does, I will forward you that information.
Thank you. We have about 10 minutes left. Does anybody from the panel has any questions from members? All right, Tom, I was wondering if you had a question for the panel.
Yes, absolutely. Well, I want to thank everybody for being here and part of this. Of course, it's great to finally see this come together. Judge Lowenthal, you spoke a little bit about some of the exclusions from the program, and I think it'd be interesting to hear, you know, whether you thought those made sense in practice. You know,
I don't think they made sense. They were put in when the Assembly bill in late 2014 was going through the legislature for political considerations to make it more palatable to the district attorneys who opposed the bill. Tom, I forwarded you one published case that I actually handled. I think you cited it in your summary, which was a gentleman who was mid-40s, no criminal record, literally had never been arrested, was pulled over for some innocuous traffic violation. Officer looked in his trunk and he had a pair of, I think what they're referred to as nunchucks. And it was unclear if they belonged to him or belonged to his 19-year-old son. The probability is that they belonged to his son, but he was charged with possession of a deadly weapon. I attempted to confer diversion in that case. It was challenged and it was reversed because of that the exclusion of the deadly weapon exclusion from the bill. So my strong recommendation would be to have as few exclusions as possible, to make it as broad-based as possible. I mean, the reality is, in our complex society, you know, we have close to 1 million misdemeanor filings last year, a little bit less, traffic and non-traffic. The sheer magnitude of filings, I think precludes us from doing justice if we try to employ a one-size-fits-all style of justice. Every person is different, every case is different, and the more discretion that is vested in the bench to look at these cases individually and decide if diversion is warranted, I think the better.
And just to be clear, there is some sort of appellate review, it sounds like, even in these misdemeanor cases.
There are, yes.
I was also had a question, Judge Lowenthal, if you could maybe give the committee a few examples of sort of sample diversionary programs you recommended to people so we could get a little bit of a flavor of what it might look like in practice.
Well, these were first-time offenders charged with the lowest level offenses, petty theft, trespassing, innocuous battery where there might have been, you know, a slight shove. Someone having a slot machine displayed in a store that turned out to be operable. And in each case, it's just fashioning a sentence that would be appropriate. Sometimes that entailed community service. Sometimes impulse control counseling, petty theft counseling. Sometimes AA meetings. You know, it varied.
So I had a question for DA O'Malley. DA, I think that especially when we're talking about first-time offenders, we're hoping to put people who have sort of, we don't want a criminal conviction to be a gateway to much more serious criminal activity. That's the gold standard here. That's why I asked Judge Lowenthal about, you know, the recidivism rates. I was wondering if you have anecdotal experience or actual hard data that not only on completion rates, but that participation in these types of programs actually does reduce sort of the gateway into more serious crimes. Oop, you're on mute.
One of the key factors that we're always looking at is we don't want to over advocate for somebody that pulls them further into the system. And so for the lower level misdemeanor diversion, for some of them, they may go into a program. For some of them, they may just be not in the court system for a period of time. And after a period of time, their case is dismissed. I can tell you that from our felony diversion programs that we have, as our early intervention court has, out of over 200 people, only 10 have not succeeded. And that shows it's a tremendous, tremendous rate.
And what does succeed mean? Can you just what does succeed mean?
That means that they have completed the program and they have not come back into the criminal justice system. So, and the program consists of people getting into school. It they oftentimes we have peer specialists who are people who have lived experience, who have gone through a certification training to be a peer specialist, which makes a big difference because, you know, when somebody comes into court or even when they're talking to their lawyers or they're with the DA, it's a different environment than if they're talking to someone who shared a similar experience of being criminal justice involved. And so for me, that's a big area where we're pushing for more resources and more training for people with formerly incarcerated, lived experience, returning citizens to be certified to act as peer specialists. When somebody needs help or they feel like something might be going awry, they can talk to someone. So in our early intervention court, it's been very successful. We have a longitudinal study with our mentor diversion court, which started over 20 years ago, dealing with young offenders, young male offenders who are involved in the commercial side of drugs. So the sellers, and out of that, there's been thousands of young people who went through the diversion program. In the beginning, we had men from the community who served as mentors. Now we have people with lived experience who are serving as mentors. And in that program, there's overall, over the 20 years, averages an 80% success rate, meaning we did not see those individuals again. And so I do believe, and I said this earlier, that there are ways to put together programs that are investments in their future. What I worry about is having a rote program, because I do think that individuals come in with individual issues. And the more we can personalize these programs and the more we can offer services that are appropriate to that person, then the better off we're going to be, and for sure, the better off they will be.
Thanks. Before I get to you, Mr. Adams, one quick question back to you, DA O'Malley. Do you have written guidelines as to who is eligible to participate in these programs? You have a relatively large office, so how does that get disseminated down? Or is it just up to the prosecuting DA who happens to have the case?
So we do have guidelines, and there's a DA who's in charge of the program. That's her primary responsibility. So anybody who fits our criteria, which could be low-level robberies, up to low-level robberies, that they get referred to the program. And then the program, it's really the judge ultimately has the authority whether or not they're going to stay and that they're going to be accepted into the program. And it's very, like the name says, it's very collaborative. You know, the goal is really to get people in there who are prepared to engage, and not everybody is. And so, you know, it doesn't mean we give up on them. We just keep offering it. And anytime during the pending of the proceeding, if they decide they do want to participate in early intervention court, then they're going to be accepted into the court.
So every low-level robbery, let's say, goes through this particular district attorney? And then
goes through well, there are 8 branches that we have, 5 of which are criminal driven. So the charging deputies are the ones who make the calls. It's the same thing we do for, if it's a sexual assault case, it gets referred to the sexual assault leader so that we know whether or not they're going to take the case and things like that. And so all of these go to the clearinghouse.
So the line DA gets the case, then refers it to the supervising DA in that case.
It's actually the charging DA gets the case, and the charging DA then refers it for collaborative court.
And it's up to them, or their guidelines as to what get this?
Their guidelines.
Thank you. Mr. Adams.
Thank you. I just wanted to emphasize that when the committee is considering diversion options, please be mindful of the fact that diversion, while it's wonderful from people who are first-time offenders and are new to the criminal justice system, the real intrinsic danger from my perspective is diverting people from felonies. It's so important to understand that once you have a felony conviction, it is a fundamentally different experience with the criminal justice system. When a person has a felony on a first-time offender, you know what they usually get is probation in most instances, but that means that they now have in their homes probation officers in full regalia, guns on their sides, knocking on the door, letting themselves in, traumatizing families, and the people are in there who had nothing to do with the criminal act because the criminal defendant who's on probation now has abdicated that person's Fourth Amendment rights by accepting probation. It is a very traumatic experience for all involved, and it sets a narrative in a community that is hard to undo. So getting people out of the criminal justice system prior to felonies is a paramount concern for many of us.
I appreciate that felonies lead to that, but do you think that if we could dramatically reduce the number of misdemeanors, that then trickles up to reducing felonies?
To some degree. I mean, the reality is you clear out, you take away drugs, alcohol, and romantic relationships, and 95% of your jail is empty, right? So in many ways, you're already doing as much as you can by way of, you know, the PC 1000 and the Prop 36 and the domestic violence counseling that we require when there's instances of that. There's a lot of good work that's already done in that fashion. What you're oftentimes left with are people that are suffering from coexisting mental health issues that are coupled with self-treatment through drugs and alcohol. That's a massive problem. And people who are essentially just in a state of transiency and are constantly coming in contact with the law, becoming numb to it, and it just escalates the behavior when this culture emerges that this is how we get things. So while it's possible to get involved by stopping misdemeanors from becoming felons, it's not always the case. It doesn't always work that way.
Can I just add to that?
Yes.
That what we found with the cases, first of all, to be clear, that our collaborative courts for felonies are pre-plea, so they are not convicted. They're not. It's not like the Penal Code section that 1000.12. They had to plead entry of that judgment, and that were very few people going into that because our early intervention court, our mental diversion courts, those are all charged but no conviction. And at the end of it, they were likely to get a dismissal. What we found with our felony courts is that very few of them are misdemeanors that continue to commit crimes. We're seeing more, so crimes like car thefts and some economic crimes like these low-level robberies that don't involve violence as much, like knocking someone down and taking their phone. Well, that, I don't want to say that's not violent, but we'll call it the Estes felony robberies. And so I think that, again, we don't want to over advocate for somebody who doesn't need it. Some people commit low-level misdemeanors because they, don't have any money, and so they go steal something. That's very different than how we engage with that person would be very different in how we engage with someone who's involving a victim or something like that.
Thank you. Senator Skinner, last question.
I want to make sure I was unmuted. In response to some of the comments, and Anthony Adams, I think you kind of hit the nail on the head. It's been commented by almost everyone, even in the first panel, that when we look at whether it's misdemeanor or felony charges, if we had drugs, alcohol, and some impulse behaviors removed from the picture, and mental health problems removed from the picture, we would have to do nothing else. Our population would probably be shrunk by 75%. That may be it. I don't want to do a number because it's not appropriate, but we certainly know that it's those factors that lead so much to these behaviors that then end up with people being in law enforcement and then to our courts. And the point I'm making is that when we look, say, even DA O'Malley at some of the economic crimes, some, and again, without really data in front of us, some of this is speculation, but sometimes these economic crimes can be led to the fact that with the person with the record, we have already created a situation where we've made it extremely difficult for them to be able to have any type of adequate enough income. I mean, the record alone is such an obstacle to so many things available to others that would allow one a path to full functioning within the society. So I guess and this is the whole purpose of not only this discussion but our task force is how do we revise our penal code and our practices in such a way that is smart on public safety. And so I guess I'm not really making a question, but if either of you had a comment, Anthony, about any other thing that you have found that's working to help guide us or inform us, that would be great.
The early intervention and the early recognition of people with mental health issues is incredibly important. The quicker we can identify somebody in that category, the better we can address their issues. Collecting information about their past, their history, whether they've been regional center clients, whether they have had any kind of medical conditions that would lead to behaviors or psychiatric issues, all those things take time. And one of the things that the legislature did recently that was remarkable was regarding veterans diversions. You guys required law enforcement to identify veterans in the jail and to do that at that early stage so that the criminal justice partners were made aware of that person's status. And it's in that same vein, if we had the early recognition of somebody with a mental health issue, that would go a long way towards achieving some of the goals we're all working towards.
Well, thank you very much. As I said with our last panel, we promise to be back in touch with you. We really do appreciate your time and your thoughts and your energy on this. And we're going to take another 5-minute break before our next panel. So thank you all very much.
Thank you so much.
Thank you.
Thank you.
Thank you.
Oh.